Ladies and gentlemen, why don't we reconvene for our fourth and final panel of the afternoon? Okay. Our fourth and final panel of this afternoon is the commentator is Professor Amy Morris Hess from the University of Tennessee. We have our panelist Louise Lark-Hill from Widener University and John Martin from Ohio Northern. The title of the panel is New Challenges.
Thank you. On behalf of John and Amy, we realize we're the last group of the day, so we appreciate that we still have an audience to whom we can present, so thank you. And also something John and I were talking about earlier, I think that we have the title of our section being what it is because they couldn't decide quite where to put our papers, don't you think? So we're New Challenges. And I'd also like to begin by thanking the Journal and the Law School, the Foundation, and also the organizers of the event. The trustee named in this instrument shall not be liable for the trustee's acts or failure to act except for willful misconduct or gross neglect. Well, today we've devoted a significant amount of time to talking about changes to the Uniform Probate Code and the impact that they have on the existing law as we know it. But one of the things that wasn't changed in the UPC was the fact that we have fiduciary duties that have default rule status. And so if we look at the language of the UPC, it calls for trustees to observe the standards in dealing with trust assets that would be observed by a prudent person dealing with property of another. And then with respect to the probate of wills and administration of estates, the personal representative is a fiduciary who shall observe the standard of care applicable to trustees being liable for loss resulting from breach of fiduciary duty to the same extent as the trustee of an express trust. But we then have qualifying language that's attached to the standard of care, and that is except as otherwise provided by the terms of the trust. So when we look at those core fiduciary duties that are associated with trusts, we talk about loyalty, we talk about impartiality, and we talk about the duty of prudence in the conduct of trust administration. And in this day and age, I can't help but question recognizing these core fiduciary duties and then acknowledging that they can be contracted around. Centuries ago, when trusts were primarily used to transfer and hold title to familial land, trustees usually were members of the family or friends of the settlor, and they served gratuitously. And so for these amateur trustees, to have an exculpatory clause really made sense. You were trying to protect that friend or that family member, or perhaps induce them into coming on and taking on this responsibility. Well, over time, the dominant form of wealth in this country shifted from land to financial assets, and with it came those fee-paid professionals that were the typical trustee. Exculpatory clauses continued to be used, and some deemed this practice as dubious. And as Bogart said, after advertising great skill and ability and impliedly promising to use all that care and capacity in any trust where its chosen trustee, the bank or trust company should not insist that the settlor hold the trustee to the lower standard of performance. Well, in the early 20th century, it was unclear whether or not trustees could escape liability by use of these exculpatory provisions in trust instruments. Some courts use strict construction, and so by construing those clauses narrowly, they found they weren't applicable in a given situation. There were other jurisdictions that found these clauses to be against public policy, and so therefore they were unenforceable. And then there were still others that appeared to readily invoke these exculpatory clauses, resulting in trustees being shielded from liability for negligent acts. Well, those who considered exculpatory clauses to be enforceable typically did so by viewing voluntary bargaining as part of the trust, including the ability to modify these fiduciary duties. And so using this contractarian analysis, we had an understanding and an underlying assumption that all parties had full information and entered into this arrangement with equal bargaining power. Well, even proponents to the view that fiduciary duties could be contracted around realized that there was a limitation to this practice. And for instance, when we talk about that duty of loyalty or the trustee's duty to act in good faith, John Langbein, who of course was with us today, he's noted that the inclusion of terms such as these indicate the settler didn't understand the instrument because no informed settler would knowingly agree to such provisions. So there were some duties that couldn't be contracted around. The UPC does not address exculpatory clauses. And by calling for liability for breach of fiduciary duty to mirror that of a trustee of an express trust, the UPC leaves this matter to other law. And while the UPC doesn't expressly address exculpatory clauses, the Uniform Trust Code and the restatement both do. Both the Uniform Trust Code and the restatement provide that exculpatory clauses are generally enforceable. And both state that such clauses are unenforceable if insertion of a clause into the instrument was itself a breach of fiduciary duty. And both also provide that exculpatory clauses should be strictly construed and they preclude protection from bad faith and intentional misconduct. At the present time, both also preclude protection from reckless indifference, although the Restatement Third's fourth volume, which is coming out in 2012, or expected to come out in 2012, would remove that word reckless and then broaden unenforceability to indifference to the fiduciary duties of the trustee, the terms and purposes of the trust, or the interest of the beneficiaries. Well, when we're trying to determine whether or not an exculpatory clause was included in an instrument as the result of the breach of a fiduciary or confidential relationship, among the factors to be considered are whether the instrument was drawn by the trustee, whether the trustee was serving as the settler's conservator or as the settler's lawyer in providing the trust instrument, whether the settler received independent advice regarding the provisions, whether the settler was able to understand and make a judgment concerning the clause, and the extent and reasonableness of the provision. The Uniform Trust Code puts the burden on the trustee to prove that the exculpatory clause is fair under the circumstances and that its existence and its contents were adequately communicated to the settler. And now the upcoming restatement would also place this burden on the trustee. Commentary to the Uniform Trust Code considers the burden of fairness and communication satisfied if the settler was represented by independent counsel, even if the settler's lawyer used the trustee's form. So it's unclear whether or not this would satisfy the trustee's burden under the upcoming provisions in the restatement. Well, today, most states approach exculpatory clauses and trust instruments in one of three ways. Some follow the restatement principles. Some have followed the Uniform Trust Code, and some states, by statute, have nullified exculpatory clauses as being against public policy. Something that I find of particular concern, however, is when we have a lawyer, the lawyer's firm, or an institution with which the lawyer's working, named to a fiduciary position and including an exculpatory clause in the governing instrument. Because it was not, in the not too distant past, that it was frowned upon if a lawyer attempted to influence a client to name him or her to a fiduciary position. The Model Code of Professional Responsibility, which came into effect in 1969, had an ethical consideration that stated, a lawyer should not consciously influence a client to name him as executor, trustee, or lawyer in an instrument. In those cases where a client wishes to name his lawyer as such, care should be taken by the lawyer to avoid even the appearance of impropriety. Well, when we had the Model Rules of Professional Conduct come out in 1983, we had absolutely no language that addressed this contention. In fact, you could say the Model Rules went silent. We took it out and we said nothing about it. And then with the coming of the 21st century, with Ethics 2000, we came full circle. And in commentary to Model Rule 1.8, we said, there is nothing improper about a lawyer suggesting to a client that he or someone in his firm be named to a lucrative fiduciary position. In 2002, we had an ABA, a formal opinion that posited that there's no inherent conflict of interest under Model Rule 1.7, and that's our basic conflict of interest rule, when a lawyer serving as fiduciary appoints himself or his law firm as legal counsel for himself as fiduciary. The fee that's generated from such an arrangement doesn't constitute a gift, because that would have triggered 1.8c, nor is it viewed as a business transaction with the client, because that would have triggered 1.8a, which calls for stricter mandates in terms of getting client consent and entering into the arrangement. So while this arrangement is not an inherent conflict of interest, commentary to Model Rule 1.7 indicates that such appointments are subject to the general conflict of interest provisions if there's a significant risk that the lawyer's interest in obtaining the appointment will materially limit the lawyer's independent professional judgment in advising a client about the choice of a fiduciary. And then in obtaining a client's informed consent to such a conflict, the client should be advised of the nature and extent of the lawyer's financial interest in the appointment, as well as the availability of other candidates for the position. Under Model Rule 1.7a, should a conflict exist because of the lawyer's personal interest, then under 1.7b, that representation can go forward if the lawyer reasonably believes that competent and diligent representation can be rendered to the client, and the client gives informed consent confirmed in writing. The model rules give the lawyer the task of deciding if the situation is a consentable conflict. That is a conflict that can be resolved by client consent. And in my paper, I cite to a 2005 article of Professor Monopoly, who's here, still here, should I say still here, so it doesn't matter. She points out that the ABA opinion holds lawyers to a stricter standard than do the model rules because it provides for a duty of disclosure by the lawyer, notwithstanding whether or not 1.7 is applicable. And I hope I paraphrased that appropriately. The early 21st century brought another change to the model rules, and that is the recognition of reciprocal referral arrangements between lawyers and non-lawyer professionals. And so incorporated into Model Rule 7.2, and it's at 7.2b4, we provide a lawyer may refer clients to another lawyer or non-lawyer professional pursuant to an agreement that provides that the other person can refer clients or customers to the lawyer. There are limitations on this too, however, and that is the agreement can't be exclusive, and the client has to be informed about the existence and the nature of the agreement. Well, with the widespread use of exculpatory provisions limiting the liability of fiduciaries, and with representation by counsel satisfying the fairness requirement that's called for with exculpation clause use, with lawyers given the green light to suggest themselves or their firms for fiduciary positions, with the consentability of a conflict turning on the involved lawyer's reasonable belief, and with revisions of the model rules acknowledging and approving reciprocal agreements between lawyers and non-lawyers, such as financial institutions, it seems we may have a situation that presents the perfect storm. In the UPC, the fiduciary duties continue to be recognized as default provisions with reliance on other law to set the applicable standards. And so while perhaps viewed as beyond the scope of their mandate, it seems that the drafters to the revisions might have weighed in on the fiduciary's use of exculpation clauses or examined the propriety of the nature of default rules when we're talking about fiduciary duties. But rather than taking this matter on head on, we didn't have any UPC revisions made in this regard. Now, perhaps these matters were off limits in terms of this round of revisions. Or perhaps the drafters of the revisions were comfortable with the notion that fiduciary duties can be contracted around. Or perhaps the drafters of the revisions were comfortable with relying on the standards of other law, especially in light of the current position taken on exculpatory clauses when we look at the Uniform Trust Code and the restatement. However, even if the drafters of the revisions chose to endorse these provisions through an action, it seems that an opportunity could have been seized to weigh in on the nature of fiduciary duties and the practice of exculpation. Since the default nature of fiduciary duties was left intact, a position might have been voiced on where to draw the line on those modifications. Should the cutoff be bad faith and indifference, willful misconduct and gross neglect, talking about ordinary negligence? Is our ultimate goal one of fairness? And we've heard fairness mentioned several times today. Well, we have to remember that there's a duty to administer the trust solely in the interest of the beneficiary, and that's been characterized as the most fundamental of all the fiduciary duties. So it seems that the revisions to the UPC could have underscored this requirement and perhaps recognized that there are some duties that shouldn't be contracted around. And so if we weigh public policy concerns, and if we think of client protection, and then the responsibilities that are associated with fiduciary duties, it may be that that standard of prudence shouldn't be so easily abandoned.
You might be interested to know that the planning for this symposium began just about 2 years ago this month. And of course, the senior editorial board of the journal simply was handed the project as a fait accompli, and I have to say they carried off their assignment with superb efficiency and superb action, and all of us who have attended are certainly indebted to them for their fine work. My paper argues that the Uniform Probate Code should adopt a system of non-judicial estate settlement. Dan Kelly's talk tells me that I'm really focusing on transaction costs without using that term. The indictment of traditional estate settlement through the probate system is pretty well known. Probate is too costly, there is too much delay, and probate lacks privacy. So the public wants to avoid probate, and attorneys and academics encourage probate avoidance. Our recent support of the pay-on-death real estate deed certainly proves that observation. In piecemeal fashion, legislatures have responded by enlarging the use of small estate procedures and affidavit collection devices. A small estate in some of our jurisdictions is quite large. Oregon has a small estate procedure for up to $275,000 in value. As many as a half dozen states permit assets as large as $100,000 in value to use an abbreviated procedure. The expansion of these summary procedures tells us several things. It tells us there is a demand for something other than traditional probate, and it tells us that that something else should reduce delay, should reduce expense, and should minimize or eliminate filing of personal information that will be exposed to public view. The informal settlement procedures in Article 3 of the Uniform Probate Code most certainly did address many objections to traditional probate. But a close examination of Article 3 reveals significant shortcomings remain. These include the fact that there is no ability to use an informal procedure to identify the heirs of an intestate decedent. A detailed inventory is required in every estate. Invariably, courts require use of some type of closing procedure, and the least cumbersome closing procedure under the Uniform Probate Code is the filing of a sworn statement that settlement has been completed. But if you look at the closing statement, you see the verifications that are required impose requirements that contribute to delay and expense. For instance, the sworn statement cannot be filed until 6 months have elapsed since settlement began. The personal representative must verify that the claims period has expired. With publication in a newspaper of notice to creditors, the claims period can be 4 months. Without publication, the claims period is 1 year. So either the delay for 1 year is encountered, or publication costs must be incurred. Another required verification in the closing statement is that an accounting has been given to all beneficiaries. An accounting entails more expense and more delay. I contend that estate settlement can be simplified and even become attractive, and that those objectives can be attained through what I call a registration system. A registration system would be an optional settlement choice within the Uniform Probate Code. It would be attractive when all parties are in agreement. That means they have no disputes among themselves, no disputes with creditors. They simply want to transfer title from the decedent to the proper beneficiaries and to do it promptly. Those are the vast majority of estates. Under a registration system, the will of a testate decedent would be recorded in what I call the Office of Estate Settlement. Or, for an intestate decedent, an affidavit of heirship would be recorded. In response to either action, the registrar would issue a statement of registration that would be evidence that the registered document, either the will or affidavit, is presumptively valid. The person who registers the will or files the affidavit would be obligated to give notice to all other potentially interested parties. In some estates, that will be all that needs to be done, because the will or the affidavit might be a sufficient muniment of title. Of course, there will be a few estates where there might be a challenge to the will or a challenge to some statement made in the affidavit of heirship. And in those few cases, the parties take a stroll down the hallway in the courthouse, and they have to file an action to call the court's attention to the question. And of course, there will be many cases in which a personal representative is appropriate. Assets may be numerous and may need to be collected. There may be a need to sell assets to increase liquidity, to pay creditors, and to allocate assets among and distribute assets to the multiple beneficiaries. If a personal representative is appointed under a registration system, the personal representative would be required to perform only those tasks that need to be accomplished. There would be no laundry list of mandatory tasks that every personal representative must perform. So there would be no required waiting periods. So the preparation of an inventory, or the giving of notice to creditors, or assembling an accounting, or using some type of closing procedure would all be actions that a personal representative might take or might choose to do without. Under a registration system, the personal representative's authority would continue only for a finite time. That time would be noted on the certificate of incumbency issued when the register designated the personal representative. The personal representative's authority could be extended for reasonable cause, but when the time expires, the administration of the estate simply ends. There's no need for a mandatory closing procedure, nor should there be any reason for a court to be concerned about open estates. If a personal representative has been derelict, an interested party can obtain judicial oversight by filing an appropriate request. I submit that a registration system along these lines will address the deficiencies of traditional probate and cure the problems that infect estate settlement, even under Uniform Probate Code informal procedures. Even under the UPC, delay is caused by imposing set time periods and by requiring steps that either are not needed or not desired in a particular estate. Under a registration system, there would be very few mandatory steps, so the settlement can proceed as quickly as desired and can simply end when there is nothing more to do. Indeed, this process is much like the settlement of a funded revocable trust following the settlor's death. Expense should be reduced under a registration system simply because of the elimination of steps that are neither needed nor desired. Moreover, the toll and frustration that accompanies traditional probate is eliminated. And so that's a reduction of what we might call emotional or psychic expense. Lack of privacy is a significant negative under traditional probate and for settlement under UPC procedures. Probate records are open to the public primarily because they are part of judicial proceedings. A registration system would not involve adjudication, and so the registration system lies outside of the judiciary. Therefore, the applicant who registers a will or the affiant who files the affidavit of heirship may at that time request that the file be accessible only to heirs and beneficiaries. Well, that of course raises all sorts of legitimate concerns about protection for those who may claim an interest, and about protection for creditors, and about documenting land titles. I've already mentioned that the one filing the will or affidavit is obligated to give notice to all who are affected by contents of that document. If anyone who receives notice believes grounds exist to challenge the will or affidavit, self-interest will motivate him or her to take action. Anyone else and any creditor who has not received actual notice is entitled to inspect the list of all decedents for whom a registration has been made, and to learn the identity and the address of the personal representative or of the one who has filed the will or the affidavit. If contact with the personal representative or with the one initiating the settlement procedure does not resolve the question, does not result in a creditor's claim being paid, then we walk down the hallway and we find the window where we file a petition with the court. Maintaining a proper chain of title to real estate is really no more of a problem under a registration system than under the informal procedures of the Uniform Probate Code. Title to land is evidenced not in the probate court records, but in the office where deeds, liens, and other real estate documents are recorded. Thus, estate beneficiaries under a registration system have the same two choices that they have under the Uniform Probate Code informal procedures. They can record the will or the affidavit of heirship in the office of the Register of Deeds or recorder, whatever that office is, and that may act as sufficient evidence of title. Alternatively, they may have a personal representative appointed, and the personal representative then conveys by deed to the proper distributees, and that deed is recorded and the chain of title is complete. And that's, of course, the system that's used under informal procedures. So, in conclusion, I suggest it is highly desirable to add to the Uniform Probate Code a non-judicial registration system for estate settlement, because that system will address and redress public objections to delay, expense, and lack of privacy. Amy?
Good afternoon. I am Amy Morris Hess, and first I would like to thank all of you for still being here. It's wonderful to see so many faces. I'd also like to thank the ACTEC Foundation for sponsoring this wonderful symposium. I've learned a lot today, and I've enjoyed it. And finally, I would like to thank the students of the Journal of Law Reform. You've done a wonderful job. I can't imagine a more smoothly run symposium. I'd like to congratulate Larry Wagoner on 30-plus years of law reform. He may call it aspirational, but I think all of us would like to be able to say when we retire that in the course of our professional lives, we made the law better. And what I know is that Larry can. He actually can say that. I was relieved when Larry said that he thought law reform was aspirational, because I come from a state where the legislature and the practicing bar look upon uniform laws, I think I'll be polite and say with skepticism. I got the job of being commentator for these two excellent papers because I happened to mention to Anne Marie Rhodes that I was thinking about writing a paper myself called The Myth of Uniformity. That is not a criticism of the Joint Editorial Board of the UPC at all. It's rather a comment on something that John Langbein mentioned in his keynote speech. The drafters of the uniform laws very carefully consider all of the possible alternatives, and they write a statute, as Larry said, that mediates between rules and standards and tries to strike a middle ground and not get too far ahead of the profession. And then in some states, the legislature, usually with the help of the bar and sometimes with the help of the Bankers Association, very carefully goes through and deletes anything that is the slightest bit original or creative. I had to laugh this morning when Larry was talking about the changes made in the UPC because I was ticking them off. Let's see, well, Tennessee does have the Uniform Statutory Rule Against Perpetuities, but it still has the model probate code for intestacy, basically. A surviving spouse with children gets a third of the estate. Nothing is said about multiple marriages. They tried to enact a surviving spouse's elective share statute that was modeled after the current version of the UPC that takes into account length of marriage and so forth, and they bungled it. And so that's kind of the position I'm coming from on the UPC. Tennessee has enacted the Uniform Trust Code, but as I described a minute ago, they very carefully went through the statute, and every place there was anything the slightest bit innovative, they deleted it and codified the common law. Now that does give us a trust code, which as several people have mentioned is better than no trust code at all, but it seems like a terrible missed opportunity. So I decided that it might be fun, since I knew I couldn't get the Myth of Uniformity paper done by the symposium deadline because I had some other deadlines, I decided it might be fun to try to look at these two papers through the lens that I had drafted for my model of uniformity paper. And I've noticed two things that seem to be different about trust and estates lawyers as compared to, for example, contracts lawyers. First, more trust and estates lawyers than any others seem to be wedded to 500-year-old law as if they were joined at the hip and you just can't separate them. When John said this morning that he was glad that the Indiana bar admitted that the reason they didn't like the UPC was that it was too new, I breathed a sigh of relief because I thought I've lived in the only state where people said things like that. It's kind of nice to know that it's not, it's nice to know that it's not completely unique, but it's also kind of disheartening because I think we need to figure out a way to inculcate our students who are serious about trusts and estates with the sense of adventure that I see in the students of contracts and commercial law. It doesn't seem to me that the Uniform Commercial Code, for example, gets quite the scrutiny section by section when states adopt it that the Uniform Trust Code and the Uniform Probate Code have gotten in my experience. There's another aspect of the difference between contracts people and trust and estates people that I think might inform our debate concerning these papers and perhaps some others today. And that is our appraisal of the intelligence and autonomy of our clients. I think most of us in this room treat our clients, and our students for that matter, as responsible and intelligent adults. But I don't always hear that kind of confidence in people's decision-making abilities in what I hear and see in suggestions for law reform, particularly in this area of the law. I don't want to get into the debate about whether we should construe a trust as a contract or a conveyance. John Langbein, Rob Sitkoff, Melanie Leslie have done an excellent job, I think, of covering that, and Louise has been kind enough to summarize in her article some of the suggestions that have been made with respect to exculpatory clauses by people who take that position. But I think we can learn something from the contract versus conveyance controversy and from what I have observed about the difference between the way contracts folks look at their clients and the way I think we do. I think we can observe something about exculpatory clauses. First, I agree completely with Louise that when you hire a professional trustee, you're hiring them for their expertise. They've held themselves out as experts, and it's an incredible sleight of hand to turn around and say, I'm wonderful at this, but oh, by the way, I won't be responsible for any of my mistakes. So I think that certainly at that level, we have to agree with Louise that an expert trustee who is paid as an expert trustee should not be able to eliminate responsibility for exactly what he, she, or it is being paid for. I also agree, but I think this is a slightly different issue. I agree that a lawyer who drafts a document under which he or she is going to be a fiduciary is engaging in conflict of interest. quite aside from whether it should be against public policy to have an exculpatory clause at all. But a lawyer who does that is functioning in two roles. She's representing herself, and she's also, as trustee, and she's also representing her client, and she's drafting a document that's favorable to herself. So I have to agree completely with Louise's professional responsibility analysis concerning an attorney who is also the fiduciary. But beyond that, I would prefer to think of grantors of trusts as being as autonomous and sensible as obligors in a contract. And so if a grantor of a trust wants to contract, as several other commentators have suggested, for a lower standard of care in exchange for lower commissions, it seems to me we ought to let them have at it, let them do it. And so ultimately my conclusion concerning exculpatory clauses is that what the Uniform Trust Code suggests in section 1008 is pretty close to where I think the law should be. Now I'm quoting from Louise's paper because I confess I didn't bring my copy of the UTC. But it says, a term of a trust relieving a trustee of liability for breach of trust is unenforceable to the extent that it, one, relieves the trustee of liability for breach of trust committed in bad faith or with reckless indifference to the purposes of the trust or the interests of the beneficiaries, or was inserted as the result of an abuse by the trustee of a fiduciary or confidential relationship to the said law. An exculpatory term drafted or caused to be drafted by the trustee is invalid as an abuse of a fiduciary and confidential relationship unless the trustee proves that the exculpatory term is fair under the circumstances and that its existence and content were adequately communicated to the said law. Here we have two intelligent, autonomous people, the trustee and the grantor, and they have decided to contract for a lower standard of care. Not for no standard of care, but for a lower one. Not for reckless indifference, but for exoneration from making everyday mistakes, which is what I call simple negligence. Well, I don't have any cause for alarm in that because I assume autonomy. As far as the Uniform Probate Code's failure to mention exculpatory clauses, I think that Louise is exactly right, although I guess Larry can tell us if we're right. Both of us admitted to each other at lunch that we didn't really know why there is no exculpatory provision in the UPC, but suggested that perhaps the drafters thought that the other law, like the UTC and the common law, adequately took care of it. And as far as I am concerned, with the exception of the two situations I've mentioned, I would leave it at that. I think this is one area where, in effect, we don't have a new challenge because we've already dealt with the old challenge and gotten it right. What I mentioned to John at lunch was his paper has the advantage to me of assuming that the family of a deceased person is comprised largely of independent, intelligent, and autonomous people who can administer the estate just fine by themselves. And if they need help, as he says, you just walk down the hall to the judge's office and you ask for judicial construction or clarification concerning a dispute. But I also said, because of my experience with the difference between the trust and estates bar and the contracts bar, that his suggestion was so simple and so refreshing that I suspected that if it was added to Article 3 of the Uniform Probate Code, many states, and I was thinking of several in particular, would probably excise it when they enacted the UPC because it's not old, it's new. Actually, it is old in one respect. Civil law countries that have a form of universal succession have successfully dealt with estates that pose no problem to the beneficiaries under a regime that does not involve a judge for hundreds of years. And I haven't noticed that France or Italy or Spain have descended into utter property chaos. So I think probably the states that would take John at his word and enact a statute like his would find the same experience, that lots of estates can be probated without the assistance of a lawyer or a judge. That reduces the cost of probate. It also, I think, increases the reputation of probate in the eyes of the public. We all lament the non-probate revolution, But perhaps one of the reasons for it is that a lot of people think they're being forced to do something that's useless and in some ways insulting. And if we suggested to them instead that there might be a simpler way to do it, they might be a lot happier with probate. And finally, to me, I think one of the most attractive aspects of non-judicial settlement, besides its simplicity, is its respect for privacy. I did practice law for several years before I started teaching, and in the second of the two communities where I practiced, there was a newspaper, which was published once a week in a small town, and apparently the editors didn't have enough work to do. It wasn't exciting enough living in that town. About once a month, they would send a new reporter down to the courthouse to read all the wills and estate inventories, summarize them, and put them in the newspaper. That kind of added a transaction cost in terms of privacy to probating wills in that part of the country that I don't think anybody quite anticipated. And for that particular reason, I guess John's proposal looks very attractive to me. So perhaps the new challenge in the title of this fourth part of the symposium is to encourage our colleagues at the bar and our colleagues in the Uniform Laws Commission to take a page from the book of our contracts colleagues, to be more willing to try new things, and to think of our clients as responsible and autonomous adults. Thanks. Am I supposed to call?
Well, I have one response to you.
Oh, okay. We're going to let John respond to me. I don't know if Larry also wants to respond.
You mentioned settling an estate without a court and without a lawyer. I certainly anticipate legal advice will be given to these people because this would only be an option, as I envisage it, under the Article 3, and good legal counsel is needed to evaluate whether you can use something like a registration approach or whether you need a more formal procedure because perhaps there are issues that ought to come before the court. And so here's where the lawyer can exercise good judgment in selecting the proper way to settle the estate.
Okay, thank you.
And just to comment on what you said toward the end, in your small town where this is happening, that's why you use, as part of your estate plan, a pour-over provision in the will into
Yes,
an existing
exactly.
trust. So that's.
Hi, my comment is to Louise, and I just wanted to toss in a wrinkle with respect to holding trustees harmless. I worked for a big bank with a lot of, where we had a big trust department, and we were able to do the Dynasty Trust. In fact, I think we trademarked that name, Dynasty Trust. We were the first to use it. Anyway, much of that kind of aggressive planning, in my experience, is predicated upon having an investment juggernaut underneath it. So, we would never, we knew better than to ask the client to hold us harmless. We knew that wouldn't fly. However, we were often offered that by clients' counsel when they wanted us to take certain types of assets into trust, very non-conventional assets. A farm with a stable of racehorses, or something, a closely held business, or even a business that had Asian factories in it. They would offer to hold us harmless in order to get us to take it. We would, I used to say, "Hold me harmless, I'm glad," but no, to those assets. But that's where where people are trying to negotiate or to get outside of the conventional kind of investment paradigms. That I've seen that offered up. I also, in terms of lowering our fees, we were often asked, with respect to not sort of close certain types of assets, particularly when they were financial assets. They would want a family member to be investment trustee, and they would want us to basically be a trustee, but charge them only custodian rates. And we wouldn't do that because we had trouble with federal banking regulations. If we held ourselves out to be a trustee, we were liable. And we weren't going to, we weren't going to take those lower fees, and we had the liability on the horizon. But anyway, so it was really in the context of investing that I saw that being offered. It wasn't in the ordinary course.
And I don't have a problem with a provision that targets a particular investment. It's the broad exculpatory clauses that are troubling to me. And Professor Leslie, to whom you made reference and who I use as authority in my article, she says, and it's very interesting, fine, use an exculpatory clause, but give me two prices. Give me a price with it, and give me a second price without it. So, bargain for a lower standard. But I want to see two prices out there. So, and that was, I thought, an interesting approach for that.
Bob, the microphone's coming.
John, my memory is that UPC was based on non-probate, non-judicial settlement of states in states like Pennsylvania and Texas. Larry can confirm. But is there any procedure, anything like the registration procedure in any other state now? And does it have any track record?
The term registration system was dreamed up by me. I don't know of anything like it. As we said at lunch, succession without administration, which was modeled after the civil law, was in the Uniform Probate Code and met with resounding yawn. Nobody adopted it. But I think if you took the settlement out of the court, offered privacy, offered the option of not having set deadlines, set time frames, and all procedures optional, you would have something much more attractive.
No other questions? Well, thank you very much.
So, thank you all for coming. We've actually reached the end of the program, and I just wanted to very quickly, on behalf of the Journal of Law Reform and the University of Michigan and all of the journal's members, thank ACTEC for having us, host this here. We had a great time, and I know that all the symposium editors are looking forward to working with all the authors and everybody in the next several months, getting the pieces ready for publication. Just so everyone knows, if you want to see the articles when they're done, they'll be coming out in volume 45, issue 4, which should be out sometime around June. But what I'll do is, or what we'll try to do is make sure that we keep the email addresses for everybody that RSVP'd. And once they're either published or if we're able to post them to our website before that, we'll make sure to let everybody know so they can see a copy of it. And thank you again for coming. I know that a lot of you came from pretty far. So thanks, we appreciate it, and hopefully we'll have another symposium that'll bring you back soon. So thank you.